This is one of the biggest cases that have been watching this term. It deals with gun rights, and here the Supreme Court has upheld a law
moments ago. Again, the restraining order against them should have access to a gun.
When an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed.
that bars domestic violence offenders from owning firearms.
Supreme Court's Rahimi decision. Let's dive into the Supreme Court's recent Rahimi decision. This case focused on whether people with domestic violence restraining orders could still possess firearms. It sparked intense interest in the legal community. Here's the lowdown. The Supreme Court ruled 8-1 on this case. That means out of the 9 justices, only one dissented, Justice Thomas. He stood his ground, advocating for a more restrictive approach. But let's focus on what the majority decided. The big takeaway from the Rahimi decision is how it reaffirms and adjusts the text, history, and tradition analysis for Second Amendment cases. This framework helps courts decide if gun laws are constitutional by examining the Second Amendment's wording, its historical context, and how gun ownership traditions have evolved. What makes this decision special? Rahimi added nuance to the analysis. The justices didn't simply endorse old interpretations but delved deeper into applying historical analogies. They aim to ensure the analysis is relevant and adaptable to modern scenarios like Rahimi's case. This approach means that moving forward, courts will have to consider not only if a gun law fits historical precedents, but also if the reasoning behind those precedents still holds today. It's more of a thoughtful and adaptable method, aiming to balance historical respect with contemporary realities. For those Second Amendment debates, this decision is a game changer. It's not just about whether people with restraining orders can have guns, it's about setting a precedent for how all gun laws will be judged. The Rahimi decision essentially says, hey, let's make sure we're not just stuck in the past. Let's use history to inform our present-day decisions. Pending Illinois cases. Now let's delve into the details of the pending Illinois cases challenging bans on rifles and magazines. If you thought the Rahimi case was legally complex, wait until you hear about what's happening in the Prairie State. Illinois is facing a series of lawsuits, including NHR versus Naperville and Barnett versus Raoul, which are challenging the state's bans on common semi-automatic rifles such as the AR-15 and AK-47. These cases are not ordinary lawsuits. They tackle significant Second Amendment issues head-on. The core of the legal debate revolves around whether Illinois can justify prohibiting these popular firearms under the Second Amendment. It's a bold stance by Illinois. These cases have been expedited by the Supreme Court. What does this mean? Essentially, the plaintiffs are urging the highest court to intervene early and halt Illinois' ban on rifles and magazines before further legal proceedings. They seek prompt action, bypassing the usual judicial process. Why are these cases crucial? The plaintiffs argue that semi-automatic rifles serve lawful purposes like self-defense and sport shooting and are widely used. They contend that Illinois bans contradict previous Supreme Court decisions that protect individuals' rights to own firearms in common use. This legal battle holds significant implications as it could establish a precedent for how states regulate firearms. A Supreme Court ruling favoring the plaintiffs might invalidate similar bans nationwide. Conversely, if Illinois prevails, it could encourage other states to implement stricter gun control measures confidently.
Court really broadened the definition of the Second Amendment, exactly how far the Second Amendment extend owning guns. I mean, this is a major Second Amendment ruling about who can and cannot potentially own a firearm. So here, a big win.
The Supreme Court had gone the other way. I just can't imagine what the outcry would have been. That would have been something else.
You see an 8-1 decision here that says it is okay, guns out of the hands of people who are...
There has been a broad interpretation of the Second Amendment coming from the High Court in recent years, but my goodness.
Rahimi was probably going to come down.
That sounds like a common sense to a lot of Americans out there.
GVR orders and conferences. If you're unfamiliar with the term GVR, don't worry, it's basically the Supreme Court's way of saying, hold up, let's take another look. Here's the scoop. The Supreme Court has been actively rescheduling and relisting the Illinois cases for new conferences. This isn't just administrative, it signals deep deliberation among the justices. They're not rushing to a decision just yet, indicating careful consideration of all aspects. Now about those GVR orders. GVR stands for Grant, Vacate, and Remand. Simply put, if the Supreme Court issues a GVR order, it's like hitting the reset button. They grant the petition, vacate the previous judgment, and send the case back to the lower court for further review. This typically occurs when a recent Supreme Court decision, such as Rahimi, could impact the case's outcome. So if the Illinois cases receive GVR orders, it means the lower courts will need to re-examine them in light of Rahimi's new legal framework. The timing and decisions made during these conferences are crucial. If the Supreme Court issues GVR orders, it could lead to lower courts overturning the Illinois bans based on the strengthened text, history, and tradition analysis from Rahimi. This would significantly challenge the state's stance on semi-automatic rifles and potentially influence gun laws nationwide. Conversely, if the Supreme Court decides against issuing GVR orders, the Illinois bans could remain intact, at least temporarily. This scenario would likely prolong legal battles and maintain uncertainty in the ongoing debate over gun rights.
You help ensure that your son and all the victims of gun violence are not forgotten. They didn't die in vain. Designed to reduce gun violence and save lives, and I'm so proud of the tremendous progress we made since then. The year before I came to the presidency, the murder rate was the highest increase on record. And those rates are continuing to fall faster than ever. Last year,
I'm not asking you about short-barreled rifles. I know what short-barreled rifles are qualified as in the National Firearms Act.
This is a semi-automatic handgun. As quick as I depress the trigger of this Glock 19, a round comes out of the chamber.
Impact of Rahimi. Now let's see how the Rahimi decision is poised to impact lower courts nationwide. The Supreme Court ruling isn't just a singular case. It fundamentally changes how state firearm restrictions will be assessed moving forward. To begin with, lower courts now apply the text, history, and tradition analysis recently reaffirmed and refined by Rahimi. This framework serves as a guiding principle, helping judges navigate complex Second Amendment cases. They delve beyond the amendment's language, exploring historical context and traditions to determine the validity of gun regulations. What sets Rahimi apart is its expansive use of historical analogies. Rather than rigid adherence to past precedents, the Supreme Court embraced a flexible approach, considering how historical regulations can inform contemporary issues. This requires lower courts to scrutinize whether historical laws or practices justify current gun regulations, akin to using old maps to navigate modern roads, different yet containing valuable landmarks. This broader application carries dual implications. States may justify their bans by citing historical regulations that, while not identical, bear relevant similarity to their current goals. Conversely, challengers may argue that such analogies are inadequate and advocate for the protection of modern firearms used lawfully. Furthermore, Rahimi's impact extends to how courts interpret the legality of modern firearms under the Second Amendment. While the case specifically addressed firearm rights in domestic violence restraining order contexts, its principles, such as nuanced historical analysis, will influence a broader spectrum of issues, including the legality of semi-automatic rifles and high-capacity magazines.
2.7 million people are now felons in possession of firearms for something they purchased legally.
People were on notice for years and years and years.
Congressional Research Service says there are 10 to 40 million of those things purchased in the same period of time were received by the ATF. Does that sound accurate? The low-end number of the ATF numbers on 3 to 7 million. But U.S. Fish and Wildlife comes to his car and sees a gun in there with a pistol brace. What's the penalty for him now? He bought the gun legally.
Justice Thomas's dissent. Now let's examine Justice Thomas's perspective as the lone dissenter in the Rahimi decision. He's known for standing firm on his principles, and his dissent in this case illustrates that clearly. Justice Thomas advocated for a highly restrictive interpretation of the Second Amendment, while the majority of the Supreme Court embraced a broader application of the text, history, and tradition analysis. Thomas remained steadfastly opposed. He maintained his stance without compromise, insisting on stricter approach. In his view, the court should adhere strictly to the original meanings and intentions behind the Second Amendment, without stretching historical analogies to fit contemporary contexts. Thomas's dissent underscores the ongoing debate within the Supreme Court on how best to interpret the Second Amendment. Should the analysis be adaptable to modern circumstances, or should it adhere strictly to historical precedents? Thomas firmly aligns with the latter viewpoint. He believes that the protection of the Second Amendment are clear and should not be diluted by modern interpretations or broad historical comparisons. His rigorous approach contrasts sharply with the majority's decision, which takes a more nuanced approach to incorporating historical practices into modern law. Thomas expresses concern that this broader approach could lead to increased regulations and restrictions on gun ownership, a right he views as fundamental and deserving of robust protection. Thomas's dissent isn't just about disagreement on one case. It reflects a philosophical stance. It highlights a significant division within the Supreme Court over the appropriate methodology for handling Second Amendment cases, mirroring broader societal debates about gun rights and regulation. On one side are proponents of strict adherence to historical context and original intent, while on the other are those who advocate for interpretations that acknowledge the complexities of contemporary society. That's all for this video, folks. See you next time.